Amendment to the bylaws and policies, board policy IBB and IBBR, presented by Dr. Bozer.
Good evening, board members and Dr. Green. This policy is ready for action. However, I do need to mention that on the policy itself and the regulation, we mention October 1st as a date where the audits and the annual reports are due to the state and to the district. That would need to change, since we just discovered recently from the state that that should reflect a November 1st date.
State changed their date.
Okay, moved by Dr. Morley, second by Mrs. Turner. Is there any discussion? Okay.
Yes. Marcia's asking to put on the bottom.
Okay, Mr. Orson.
Well, I initially have a question. Dr. Green, you had sent us a note that you had shared the draft with the state, I think somewhere 2 weeks ago. Or I always had made a request about sharing it with the state. Have we ever shared this draft with the state, and have we gotten any comments about the draft of our policy and regulation?
We did share it with Mr. Ursi, and then Friday I did get a correspondence from him suggesting, and I took that as suggestions and advice for the things that he would like to see changed in the draft that we had. Yes.
So, do we have an opportunity to see what the suggestions he's made? I feel like I'm flying a little bit of blind here, because if there's material things in his comments I'd like to know, because
I mean, I guess I could send it all to you in an email now, if that's what we're talking
right. Well,
about.
I mean, I feel, I've had some concerns about the draft in terms of whether it comports with state law, school board policy, state school board policy, and if there are comments from the state, I'd be interested in seeing those comments to see where we do not align from the state's perspective with it before I'm to proceed on voting on the policy. Because, and I think I've expressed to our fellow board members, I'm hesitant about voting on things that I think are not in alignment, and that we have an indication, if not a strong suggestion up front, that they're not. And so, I'd like to be in a position to at least review the comments that the state has shared with you to see if there's places where we're materially different from their opinion from what we have drafted.
Yeah, and again, the state as represented by Mr. Luersti, I'm not so sure that I think I took it as his advice and suggestions, but that came late Friday to me, and I did tell him that I would take it under advisement and then proceed with in a manner that's in the best interest of the DeKalb County School District. And then I have taken his advice under advisement, as I indicated I would. But if the board directs me to provide that information now, I will certainly be happy to do so.
From where I sit, I'd like to see this stuff and also have some time to digest it, and I just wonder if under those circumstances there would be some sense for us deferring this until our meeting 3 weeks from now, so we can at least look at the comments and see if there are things. I have some other issues just from my own perspective that concern me, but I also don't want to find myself, my interpretations may also not comport with what the state's view of, and I think it would be helpful to have the state's view on our policy, since our stated objective was to align our policy with state law.
Yeah, we've worked very closely with outside counsel who assures us emphatically and unequivocally that we're in line with the law and with the state. And so, again, at the board's direction, I will certainly be glad to provide the information requested.
Well, I'm not quite sure how to proceed. I mean, because I don't want to go into a long recitation about issues that I have even with the draft. I think there are some things in there, and I have shared with council, that I don't think are supported in the text of what the state law is. You know, there are some examples with regard, for example, to charter clusters and restrictions we've placed in our own regulation that are not in the face of the statute. I understand the arguments they can make as to why they could be, but I find them troubling only because I think it would behoove us to have guidance if there's a state level interpretation. I respect our counsel, but you know, they're an advocate and they could be advocated on. Unfortunately, we've had historically where our advocates have also been wrong. And I think this is such an important and sensitive subject that I think it would be worthwhile for us to at least go through the exercise of understanding where the position we've staked out, how it's reflected in what the state's view of those policies are. Again, because of the stated reason that we've claimed that all we're trying to do at this point is to align our policy with state law. I'd like some additional comfort in that, and I think it would be helpful to see whatever comments you've received.
I firmly respect your request. Okay.
I would like to ask our legal counsel if the question, are we legally compliant in approving this recommendation? Go ahead, I'm sorry.
Yes, sir, we are. Right now, the current version of IBB that you have on the books has outdated law, has outdated requirements that we cannot enforce. So it has been our task to try and get you aligned with current state board rules, which can be difficult because they change a lot. As you know, that's one of the reasons why it's taken us a while to get to this point with the policy. But now that there's some stability in state board rule on charter schools as well as in the Charter Schools Act, we're confident that the version that you have seen that have been on the books since July for you all is legally compliant.
Would you explain for the public the many sessions that we've had to cover this information?
Absolutely. So we met over the course of, with little board mini sessions, 2 to 3 board members a session for several hours, I think 2 hours, and then we often would stay extra long to meet with board members to make sure that all of their questions were addressed. We discussed charter law, charter policy in Georgia. It's a gray area, it's nuanced. There's a lot of, I mean, it's a difficult area and it's a really crucially important area. And so we took a lot of time with the board. You guys had a lot of questions. We had a good, thorough discussion, specifically around getting you comfortable with the changes to IBB and the changes to the IBB regulation that corresponds with it. We wanted to make sure that the board felt comfortable with it going forward at this meeting.
Dr. Marley?
It constantly disturbs me that when we are in a position to make a decision that we need to make, that we're charged with making, that we continuously want to stagnate things and not move forward. We have had those many sessions. We've gone over them. It was my understanding there was an understanding, and we get at the 11th hour and there's always a way in order to defer a decision. That's why the people have us here, to make the proper decisions. The other thing is that we have a team of attorneys that we're paying quite a bit of money, and when we start letting the board be the attorneys and not the attorneys do the law and the legal things that need to be done, again, as I said earlier, then does the board want to run everything? I don't. That's why we have attorneys, and we have a superintendent that we're paying a hefty package in order to be able to make decisions. And when we as a board are constantly second-guessing the people that are put in place who are educated, well-versed, and they have to do what they need to do, I think at some point as a board we have to learn to stay in our lane and let the people do what they're supposed to do. But this constantly getting back and bantering back and forth and not being able to make a decision, I question what's the reason that we're always trying to delay a vote when it needs to be taken. This thing has been delayed for entirely too long. We've gone through enough. We've had an opportunity to talk about it. The legal team did a great job in explaining and expressing exactly what's what. I'm not willing to have this wait. I don't want it to wait. I want to vote tonight. I don't need all the other stuff. And I think that we have to begin to say, is it a personal issue or is it a board issue? As a board member, it is not my issue.
Mrs. Turner?
I'm sure that I can't articulate it as well as Dr. Marley just did, but I am in total agreement. The mini sessions were very helpful, answered all our questions, and the key phrase that you said tonight, that after each commentary needs to be repeated, is we are legally compliant with the state law. Am I correct?
Yes, you are.
All right, then I think I can rest my case. I'd like us to move forward, Dr. Johnson.
Mr. Orson, followed by Mr. Jester.
So I appreciate the desire to move on if I thought we were at a settled position, but there are some things that are material to the conversation we've had that I think are unsettled. For example, in the conversation we had in those many sessions, one of the reasons in which we talked about in sort of the background that there were limitations on, for example, the autonomy that might be granted to conversion charters that might be more limited to startup charters were things about the Fair Dismissal Act. But in fact, there was at least an appellate court decision in July that appeared to say that you can basically take the Fair Dismissal Act. I'm not saying I'm advocating that to our teachers, but that you can take it out of the equation by the virtue of the contract that you have in a charter. There are things like that that go to the materiality, how we write our decision, how we write this policy, that I'm concerned that we haven't thoroughly reviewed. Another example, in the charter cluster, you've written in the draft, the state law says an election held in the cluster. I'm paraphrasing. You've rewritten the provision to say an election held at each school in the cluster. I think that's a stretch. I'm not arguing that that might not be the right outcome. I think it's a stretch for us to try to implement by policy or regulation something that's not clearly stated in the four corners of the statute. Those are material, and I respect your position as attorneys, but it doesn't mean that it's correct or right. And I am concerned that the combination of whether there are issues that have been raised that we haven't seen by the state with a position in which we want to get to good policy, and I think we want to get to good policy in a way that we don't look to be intentionally or unintentionally antagonistic towards another, if there's a different view in state law. We may be right on the issue, and we may also decide that getting to that right position requires some action on our part, including advocacy with the state legislature. But I am not comfortable with writing policy that in which the state may, in fact, view it differently, or in my own review of it. For example, going back to the conversation we had about the Fair Dismissal Act. That's a material point which we've justified a different level, potentially, of autonomy for conversion charters, but there is, in fact, a court case that is relevant to that specific point, not settled law, not addressed by the Supreme Court yet, but it is material in the process that we're undertaking. And that's what leaves me very uncomfortable with going forward at this point, that we not find ourselves in a position in which the decisions we make put us on in an adverse, and unnecessarily in an adverse position with the state in a way that we could have avoided it, we could have had a conversation with them about it, we could have gotten clarity about certain things. So, for example, going back to example about the multiple elections as opposed to one election, there's a way to get clarity on that without having first shoving through the policy. We can ask the Attorney General's office, because it's an opinion about state law, for clarification on that position. I just think that there are things that which we represent as being compliant with the state law but are not in the state law, that it behooves us to take a practical approach to doing that, including using the institutions available to us, including the Attorney General's office, to the extent we think we need some clarity on what the applicable. If we're not comfortable with the state charter office, there are other vehicles for us to get that clarity, whether it's the Attorney General's office, whether it's the Legislative Council's office. There are other places that we can get some clarification before we stick the anchor in the water, put the flag in the sand, and we are committed in a way which we could potentially find ourselves in an adverse position.
Mr. Jester.
So over the years, the state and the district their attorneys have disagreed about law and what is compliant, right?
I mean, which district? Are you referring to?
Our school district has disagreed with the state on numerous occasions on various items.
We've been your counsel for a year. I can't speak to past counsel. We haven't had any disagreements with the state as far as I know.
All I can remember is that we're constantly disagreeing with the state on this and that. And right now, we are second guessing what's going on because we don't know what the state's guidance is on this. And I think this is a watershed moment. Are we good partners with the state? How are we going to move forward, with them or against them? And right now, the state has provided us guidance on this charter policy, and right now, I am being denied that guidance before voting. And I don't see how we can, in good conscience, be good partners with the state and not see the guidance provided by the Associate State Superintendent for Policy and Charter Schools. We are being denied that guidance. So in the absence of that guidance, that's why we're second guessing what's going on. We don't know what's going on from the state.
I'm sorry, Dr. Marley?
Respectfully, Mr. Jester and Mr. Orson, I would appreciate if you say using the I and take ownership, because I am not being denied anything at this end. And to say as a board that we're rebelling against, again, the people that we have in place in order to make a decision that's going to be best interest of our children, and to continuously take this the way that we do it doesn't really reflect that great. I'm a competent board member, and I was put in place by my constituents to do the job that I'm doing. At no time will I ever abdicate my role as a board member, as a paying taxpayer, as a member of this society, as a parent who had 2 children that graduate from DeKalb County schools. So that being denied, I have fought all my life for my rights, and I will never, ever allow myself to be denied. So I'm not a part of that group that's being denied. I don't know who you're talking about as board members being denied, but I'm not one of those. I would appreciate if you would take that responsibility for yourself. And it's constantly that we're going on with this, and we delay these decisions that we need to make, and it just does not look great upon a board that's put in place that's supposed to be filled with competent people that have been going on for months. This is not something new that has come on. It's been going on longer than that. But when we get down to the end of the wire, each time we seem to put our heads behind our tails and run away and come up with something else. What excuse are we going to come up with next month and the month after until we get it just the way that we want it to be? I'm not here for personal gain. I'm here for the gain of the greater, and that is the 100,000 plus students and the community, to make sure we do the best thing that is there. I really would like to see us move forward.
No further questions or comments? I'm sorry. Dr. Irwin, Mr. McMahon.
Thank you, Chair. Thank you, Chair. And I'd like to thank my fellow board members. Healthy conversation, very much so. We have been elected to vet all information. This has taken a while. This policy revision has been on the books for three months now? 3 months. Right. And I appreciate Dr. Green's communication with the state. It is, I think it was precedent setting that you reached out, and I appreciate that. Based on your communication, you just got it back Friday, and with that being said, I have sat in this seat for almost 3 years, and the one thing that absolutely drives me nuts is receiving information at the last second and having to vote on something that either I haven't had time, we've had it for months, but when Dr. Green, you tell us you have had communication from the state. They have issued guidance that you are considering. I appreciate that. It's a step in the right direction. I think it would be prudent for the board to understand that guidance as a way to fully understand where we are currently, and that's just where I am. I will advocate for full disclosure, full transparency, to make a sound decision based on all the facts available, and at that point in time, I feel like I would be able to vote on this. As of right now, I would like to see, our legal opinion compared to the state's, have a dialogue, figure out where we need to be, and move forward. Thank you very much.
Do we say Dr. Irwin? Your name was up first, I thought.
Well, thank you. Quick question for the attorneys. As I look at this proposed regulation for IBBR, where in the document does it discuss autonomy?
It doesn't.
So I pose that to Mr. Orson. You brought up autonomy with this policy when we're not even discussing that right now, are we?
Is this on? Oh, there it is. No, we did not include autonomy, but we don't have to copy and paste every regulation, every provision that's in state board rule, that's in the statute in order to be bound by them. We as a district have to follow the law. And so we did not copy and paste all of the same material back in.
And I don't think it was in the document prior to this either, was it? The one that we're replacing?
No, that's a newer requirement that was just enacted by the state this past November.
Okay, so really one of the things that Mr. Wilson is bringing up is the charter cluster vote. So even if we pass this tonight, we could readdress that if we weren't in line with the state per se, correct? Because this is a breathing document.
Absolutely. As a policy, we always can bring it back up and revise after there's time for consideration, just more discussion if you like. I mean, we're happy to facilitate and discuss whatever you'd like.
And one more time, just to make it clear to the public, we are in line with the state, right?
We are in line. We are legally compliant with
Legally
state
compliant
law
with the
and
state.
state board rule.
All right, thank you.
Mrs. Turner.
Yes, Mr. Chair. Can we call the question?
We can call a question. I need a second. It's been moved and second to call the question. At this time, I call for the vote. The discussion, huh? Well, I'm just saying, we'll follow the procedure first. Okay. Call for the vote. Yeah, just on the, this is on the question now only. All right. We're voting to, on the question, to call the question. So, is it? No, that's not correct. That's not, because I didn't get a chance to vote. All right, we're voting to support the question. Okay, call the question. Okay. Okay, so it's not. We need 5 votes for 2/3. Huh? We need 5 votes for 2/3, and we have 4. So the question is not called. Okay. So we're back to the discussion. Jim, it's on you.
Thank you, Chair. Ms. Lashley, regarding the law's requirement. Can you help me understand? You made a statement that says we are not required to emulate the state's law regarding...
No, well, what I did say is we don't have to copy and paste every legal obligation that the district has into our own policy in order to be bound by it. We are bound by the law as an entity in Georgia. So the state board rules, as they get passed, we are bound to them. And so when these policies were drafted, the policy and the regulation, they were drafted to be neutral so that they're not stepping out in front of the state and not, we're just getting us up to that base level compliance because the policy that was on the books is so out of compliance. And so we were just trying to get to neutral.
Right, okay. So when you get neutral is what this looks like. I'm still, what's the process in looking at the state policies and then coming up with our own neutrality? How do you pick and choose what to identify, what to review, what to submit?
Well, at the time, and I want to stress this was not just legal counsel engaging in this. I worked closely with your charter schools division staff. Using the old policy, we started from there. We looked at the provisions. We took out everything that was no longer legally compliant with current state law and current state board rules. And then we talked about, well, what is the district really doing right now? And that's what informed the regulations. So the policy tracks state law, meaning it tracks the statute. And that's generally how you do it. Your policies track state law, they track the language of the statute. And then in regulation, that's really more about, well, what are our operations really looking like? And that's where you incorporate more from state board rules, because the state board rules are much more specific about how you do your business, especially now. And so we use the statute, we use the state board rules to inform, and then also try to capture what we were doing as a district, and I use we a lot, but what DeKalb is doing as a district, as far as how it runs its charter petition review, with the goal of increasing transparency, because it's very easy to just repeat exactly what the state says in the statute and state board rule, and people still don't have an idea of exactly how those legal requirements are being embodied in the district's practices. So we rewrote this regulation in particular to try and capture exactly what happens at the district level to increase transparency, so we can increase the quality of our relationships with our charter schools, with our stakeholders, and increase the quality of submissions that we receive from the community as well. And so the idea was to put a lot of, we looked at best practices, and I've drafted the charter policies for almost all of the Metro Atlanta school districts. And so I know what's out there because I wrote those as well. And I took from some of those, we looked at best practices, what your staff did, and it was a collaboration between staff talking about what best practices they wanted to incorporate, and me talking about, well, what does the law require? What does the state board rule require? And making sure that it meshed together. And that's been the policy that you've had. We started working on it back in November and had to stop because the state updated its rules again. And so it's been a long process trying to get these policy and regulation updated for you guys.
Thank you.
Okay, this discussion can go on and on and on, but I want to make sure I'm very fair as chair. We want to hear from Mr. Orson and maybe one more, and then we just take a vote.
I'll keep my comments short. I appreciate the effort you made. To me, it remains problematic if we have a divergence from another compelling authority and my only point here, and I want to address Dr. Irwin's comment, because it wasn't meant to say that specific term about autonomy. It was that when we went through the process, and I appreciated the process we went through with the mini sessions, I was still left with some uneasiness and some lack of clarity based on subsequent information I get. And this, to your point, it's a living document. But I come from that school of thought, if I know that up front, or I feel up front something's wrong, I'd rather not ascribe it and memorialize it only to know that I got to go change it. that was just sort of the training I had. If I am uneasy with where we are, and that was true when I was a lawyer and when I was a business person. And that's where I'm at, because if there's conflicting information out there, I am of the feeling that we should receive it and digest it, and we may still disagree with it at the end. But I would feel, I'm going to stay with the I, better informed and better equipped to make that ultimate decision if, in fact, I have what I think is all relevant information in front of me. And that's why I've been an advocate for us waiting and having a comprehensive process to ensure, at least from my perspective, that we have it right.
Mr. Jester?
So I sent an email a couple of weeks ago trying to start the conversation. So if I could be given just a little leeway on some of the pieces of the policy. So in the attempt to get to neutral on this, I did have a couple questions. For instance, Mr. Orson referenced the high school clusters. A vote must be conducted at each school. I would say that's above and beyond what a school board rule requires. And if we left that part out, wouldn't that be neutral?
Well, I'm glad you brought that up, because I'd like to explain the rationale, since Mr. Orson also expressed concern about that. Whenever you have an obligation under state law, you have to reconcile that with your larger federal obligations to ensure equity of access, in particular for your families. Just so that everybody knows what we're talking about, there's a requirement that when an entire cluster of schools wants to convert to charter school status, the requirement in the law is that there's a vote held by secret ballot, and the combined vote, the combined percentage of the people to pass it is 60%. So what we put in our regulation was, rather than there being one vote that takes place at one meeting for an entire cluster of schools, that there had to be evidence that the vote was made available, that there was a vote at each one of the schools that would be subsumed in this larger charter cluster. Because when you're talking about K through 12, because you're talking about a whole cluster from the kindergarten all the way to 12th grade, for an entire geographic region, the idea that you would have one vote held at one central location that would affect all of the families that would be subscribed to that cluster, if they aren't allowed to make that, if they can't make that meeting, they don't have a voice in what happens to their child's education from K through 12 for the entire area. So what we did was we balanced the equity of access concern with your larger federal obligations to ensure equal protection, that you don't have a disparate impact on families with limited mobility to be able to take part in this important vote about their child's ability to attend free public education. So we balanced that with the requirements in the state. And when you have a reading of a statute in state law that could potentially conflict with federal law, you resolve it in favor of federal obligations. So that's why that particular provision was added, so that we would know there was a vote taking place at each school, so that every family would have at least an easier time to take part in an important decision that would affect the entire cluster.
Thank you. And back to the 2064, that the state law and school board rule defines reasons for us to deny petitions. None of it talks about innovation. So why do we make innovation a reason for denial if the state doesn't? I mean, I'm not against making innovation if we want to go above and beyond the state, but if we want to be neutral on this.
Okay. So the entire basis for the Georgia Charter Schools Act is premised in 20-2-2061, which is the legislative intent. They did not have to codify the legislative intent, but the Georgia legislature did, and they said local school districts you're supposed to increase academic and organizational innovations through increasing flexibility through the use of charters. That's the premise for the statute. So innovation is at the core of the Georgia Charter School Statute. Beyond that, one of the very first questions in the state application that we have to use, the state charter petition application, is to list out all the educational innovations that you're going to do. So I think that a charter school would have a very hard time getting approved by the state if they came with a giant blank space on question number 1 because they didn't have any innovative qualities. So it's something that the state insists on. If you look at the Georgia Department of Ed's website, the requirements for innovation are all throughout, all their FAQs, their petitioner materials, their PowerPoints on how to be a high-quality charter petitioner. It's something that you can consider. Now, that being said, sorry, I got a little dizzy. That being said, with regards to, you brought this up earlier, so I wanted to address that as well. When you look at a charter petition, whether or not it brings in innovation is just one of the many questions that you have that the district looks at with all the factors to consider whether to approve a charter petition. You take that one factor and you look at it as a whole. So for example, if it is innovative, but maybe the district does it somewhere else, but it would be innovative for that area, that's something you can take into consideration. So there's nowhere that the district said in IBBR or anywhere that if you're not innovative or that you are duplicating another thing, that is an automatic denial. We don't say that anywhere in policy. It's just one of the things the school district can look at when it's making a decision about whether or not this charter school is going to be a meaningful addition to the district's entire portfolio. You should know whether a charter school is duplicating a program that already exists or whether or not it's actually unique. So it's just one of the pieces of information that your district collects. And we kept it that way in the policy and regulation. And you'll notice when we bring up innovative, we talk about what the district is seeking. We're seeking to authorize innovative, high-quality charter schools. That's the language that's in your introduction. That's from your old policy as well that we kept.
But innovation is littered through the reasons for denial, and you're saying that the state would require innovation and would otherwise deny that. I read this as charters spur on innovation and not that innovation spur on charters. So I do not think that innovation is a requirement. I just want you to confirm that you believe that the state requires innovation to approve a petition.
They certainly require evidence of innovations that you're going to include. It's within the petition application itself. You wouldn't be able to apply to the state for a charter if you didn't have, a list of innovations that you're proposing.
Okay. I just don't. Give me one more second. Okay. I just don't see it within it being a requirement, and we're putting it in the requirements of IBB-R, and I just would like to respectfully agree to disagree with you on the purpose of innovation and us relying on that for petition denial or approval. Thank you.
Thank you very much. I would like to thank the board for the 3 months of hard work on this policy, and however it's voted. We have 7 board members, all love boys and girls in this great school district, and certainly each one of our votes will determine, our belief in how we should vote. And if all of us thought the same way, we wouldn't need but 1 board member. But for that reason, I want to make sure that the public knows that we all love children and we want to vote for the best interests of our boys and girls. So at this time, I call for the vote on whether or not to amend the board, to approve the amendment to board policy IBB and IBBR. Moved by, With all this motion of the second. All right, okay, we'll call for the vote. It passes 4-3.